this is whatever. Patrick Tatura versus Martin Yates.
Do you need to see?
No, he won't be staying long.
I hope that's the case, Judge.
Me too.
Good morning, Your Honor. May it please the court, Eric Wadowski, 65354 on behalf of plaintiffs.
Good morning, Darwin Fair, Defendant P number 31266.
All right. The plaintiff filed a motion to lift the stay and enter an order of eviction. At the time, I had not received a response, but I thought I wasn't sure where other proceedings were. I realized what was represented in the motion. And so I set this for hearing. So.
Well, Judge, I hope we would not be here today. We've been down this road a number of times. And your question is always the same question, and the answer is always the same answer, which is the Wayne County Circuit Court has not closed the file. There's still pending actions in front of the Wayne County Circuit Court that impact on the issue that's before this court. So unless we're here to argue the Wayne County Circuit Court motion, I don't know what more to say to the judge. There's really nothing more to say.
This property is located in Washtenaw County, however.
Where's the?
Yes, it is, Your Honor.
Yeah,
Yes.
the property is in Washtenaw, so I'm not clear why I'm worried about anything being litigated in Wayne County.
Well, what happened?
Let me rephrase that. I don't know why I would be worried about that with reference to this action proceeding forth in the eviction happening.
Well, the reason, Judge, is for the same reasons that occurred multiple times before this court, which is the property in Washtenaw County is subject to a settlement agreement that was entered into with the Wayne County Circuit Court judge. So this is part and parcel of this global settlement. And the reality of it is that this case on this property is still subject to the jurisdiction of the Wayne County Circuit Court judge, as has been the case every time we get before this court. As every time we get before this court, it's the same issue, Judge. And now this is, I will admit, this is the first time I've heard the court say this, but the reality is still the reality. This property is part of, and Judge, I know you do not want me to repeat myself, and I don't like to repeat myself, but I'm a little concerned that if this is not being gotten across, is every time we get to come to court, it's because of the same issues of this global settlement that is before the Wayne County Circuit Court judge.
Oh, no. Before I would, right. I mean, the reason the case is here is for whatever its reasons. But part of the reason that things were stayed is because clearly it was headed up the chain, the appellate chain. My understanding is that's no longer the case.
No. And let me
know that.
No, that's not the case. And so let me explain it this way, Judge, because I'm trying to get into your head. What the court I think is concerned about is the Washtenaw County Circuit Court case that directly impact this case. And that case, the Washtenaw County Circuit Court case, which was appealed to the Michigan Court of Appeals.
Right.
Okay, that case was dismissed, Judge, as a result of a global settlement that is before the Wayne County Circuit Court judge. So what happens in this case is still being handled by the Wayne County Circuit Court judge because the Washtenaw County case, which was appealed to the Michigan Court of Appeals, was voluntarily dismissed as a result of the settlement.
Let me cut to the chase. Why wouldn't I just lift my stay, issue the order of eviction, allow it to be executed at some future time, that they couldn't do it right away? Allow it to be executed at some future time. And if you're correct, then get a stay from Wayne County.
Okay, well, Judge, okay, now, and I'm hearing you, and I'll walk down that road with you. So the issue of the quote unquote eviction is a function of the ownership of the subject property. The ownership of the subject property is specifically before the Wayne County Circuit Court judge. So let's assume that the court says, okay, I mean, enough's enough, although it's the same issue that has been before this court multiple times, and the court says the same thing multiple times, which is, I'm not going to do anything until the Wayne County Circuit Court has made a decision, which is what, okay.
I don't know that I said anything about Wayne County.
No,
I think I said something about Washtenaw County and the Court of Appeals and the Supreme Court.
no.
Go ahead.
No. It's never about the Washtenaw County. It's always about Wayne County. It's always about Wayne County. It's never about Washtenaw County, because Washtenaw County, Judge, again, was appealed to the Michigan Court of Appeals. It was voluntarily dismissed as a result of the global settlement that was before Wayne County Circuit Court Judge.
And Mr. Fair, I'm saying, let's assume for the sake of argument that you're correct. I have a feeling there's going to be disagreement as to what you're saying in part. But why then wouldn't I just grant the relief, issue the order, and then you get a stay of that and allow an opportunity, so I wouldn't have it where it could be executed immediately, give you an opportunity to then get before the Wayne County Circuit Court, which you're saying this property is part of some global settlement, and allow that court to basically stay any order of eviction or enjoin the plaintiffs in this case from moving forward.
Okay, Judge, allow me to walk down that road. Okay, so
why is that a hard question? I don't need to be walked down the road. Why is that a difficult question to answer?
Because the hearing, no. Because the hearing that you're making reference to, that I should go before the Wayne County Circuit Court judge and ask for a stay, is a hearing that is essentially scheduled for July the 18th. That hearing will address the very point this court is making. So
then why don't I grant the relief, indicate that the writ cannot be executed until, if your hearing's on the 28th of July,
no, 18th. I'm sorry.
That it can't be executed until the 28th of July, giving the 10-day statutory period from the time of that hearing.
Okay, Judge, this is the road we always walk down, because what happens is on the 18th, we don't know what Judge Ewell will do. Judge Ewell may say, I'm not going to hear it on the 18th. Or, and Judge, I'm only going by what's happened in the past, and the same.
Questions.
You're going to have to leave. You're going to have to leave.
I do not want to argue, Judge.
Go ahead.
Case. So what has happened in the past, which is probably what's going to happen today, is that on the 18th, Judge Ewell will do one of two things, which has happened in the past. When this issue is before this court, Judge Ewell may or may not hear the case on the 18th, or may hear the case on the 18th and then decide not to make a decision until sometime in the future. Now, again, Judge, I'm not saying this for the first time. This has been the history of this case. Now, if we look at what happened here, they filed a motion to go before the Wayne County Circuit Court judge. and it was scheduled for the following Friday. At the same time, they filed this motion in front of you and filed a motion in front of the 35th District Court, assuming that the Wayne County Circuit Court judge would close the file. Because I will tell you, Judge, the question that you always ask, this is the question you always ask: what's the status of the Wayne County Circuit Court case? Is it open or is it closed? The answer is always the same. It's open. Your response is always the same. Well, I'm not going to do anything until the Wayne County Circuit Court makes a decision. And then a couple of times, Judge, you said, I'm going to adjourn it to right after when the circuit court judge makes a decision.
So why don't I put an end to that and just grant their relief?
Well, because, Judge.
Because it doesn't leave you, Mr. Fair, without remedy, because you can always ask the Wayne County Circuit Court, as I've said, to either stay that writ if they've taken some jurisdiction over this property, or to enjoin the defendants from proceeding on the writ that I would issue.
Well, Judge, this is a conversation we've had at nauseam all the time. And
well, I'm trying to end it.
And what I think but I think, Judge, what you recognize is, well, that means I've got to run to the Wayne County Circuit, the Wayne County Circuit Court, ask for a stay. The judge is going to say, aren't we going to be hearing this on the 18th? And then on the 18th, like what has happened in the past.
Well, hold on a second. No, you wouldn't have to do that if you would listen to what I'm saying. What I'm saying is I could grant the plaintiff's relief. They could not do anything. And I'm not even saying on the 18th. I'm saying for a 10-day period after that hearing. So if the judge at that point in Wayne County doesn't do anything, the 10-day statutory period would begin to run on the writ.
Wait a minute, if he, wait, Judge. Okay, so the motion that is before the Wayne County Circuit Court, which plaintiff acknowledges affects what this court can do. What they're asking the Wayne County Circuit Court is close the case, close it. And then if it's closed, then they can come to you and say, hey, Judge, it's closed. So let's go back to that point. On the 18th, if the judge does not close it, if the judge does what he has done in the past.
If the judge does not close it, you could request of the judge to enjoin the plaintiffs from proceeding forward. If the judge does close it, the writ would proceed.
Well,
that seems really simple to me.
The 10 days after that.
Right, 10 days after.
But that means a couple things. Number one, if I'm hearing the court is saying, well, if it gets adjourned to August the 10th, August the 18th, another month. And if at that time, the judge closes it, that means in this interim period between July the 18th and August the 18th, by definition, they can't do anything.
No. I'm not saying that.
Okay.
What I'm saying is, you're saying the Wayne County Circuit Court has that this is part of some global resolution.
Correct.
Okay, I'll take you at your word for that. I've not seen the resolution. That's fine. It doesn't matter to me. What I am saying is, I will assume you to be correct. I will assume also that Judge Ewell will act with his authority regarding any agreement there is. Right?
Correct.
So if I grant the plaintiff's relief, built into that are enough protections for the defendant in terms of being able to request of Judge Ewell to enjoin the plaintiffs from acting, if that case is going to be adjourned out or he doesn't rule on that day.
No. Well, okay, Judge, And I'm not going to belabor the point. I'm going to put the past in the past because we've always in this situation, and your position is real simple. Is it open or closed? If it's closed, if it's
No. The question is it pending or not?
okay.
So if the
still
issue, Mr. Frey,
Yeah.
if the issue before this court is pending somewhere elsewhere,
Correct.
that is always what I will address.
Correct.
And I think properly so. It doesn't sound like that's what's happening here. It sounds to me, based upon what you're saying, and again, I haven't seen it, that there is some resolution of this global resolution, whatever it is. I'm saying, fine. There are still issues to be decided with that. They don't need to be decided here. And so that I could grant the relief that the plaintiff requests with enough safeguards that protect the defendant until whatever that issue to be resolved is.
Well, if the court is saying that the plaintiff in this case cannot act upon any decisions of this court pending.
That is not what I am saying. That is not what I'm saying, and you know that's not what I'm saying.
Can I ask you a question? Judge, my client wants to ask a question. You say yes.
Go ahead.
Go ahead.
I mean, we did everything. It seems like we get penalized every time, not in your court so much, but we do everything. We had a global settlement. 3 pieces of property, 1 in Washtenaw, 2 in Wayne County. We all signed, the lawyers all signed what had to be done to get that done. We do everything in the agreement. My family, do everything in the agreement. They refused to sign a paper, and we're here. And we're getting penalized by getting an eviction. No matter how you rule it, it's against us. Whether we settle something on the 18th or not. We're not supposed to even be here. This is a pending case in Wayne County Court that we all agreed to settle. That guy has the ruling. I don't know what we're even here for.
You, like your attorney, are not listening to me.
You're
I
saying you're
take
gonna
you
rule
at, if
and
you
give
want
them
to
their way.
interrupt me, then you go right ahead.
No, I'm sorry. It's just, I've done everything for 7 years. I've worked up in this, and I've got, his client has jerked me around for 7 years.
Well,
And I haven't been able to live in a house I built. And then I'm gonna get an eviction notice that I know doesn't mean anything to you guys, but to my family, it means everything.
Sir, maybe you and your attorney should listen to what the court is proposing to do. Because both of you have been saying the same thing, that there is this agreement out there that is subject to the jurisdiction of the Wayne County Circuit Court. I'm not going to even begin to get involved in that.
Right. If you're, can I say one thing? I'm sorry, I'll leave.
No,
It's
no,
just-
no.
No, it's,
no.
he doesn't
Judge-
get it.
Judge didn't say. you
He's
couldn't.
always been
Hold it,
good,
hold it.
but
Judge didn't say
I
you
gotta
couldn't.
get out of here before I have a breakdown, man.
Yeah, Judge didn't say you couldn't say it, so why don't you say it?
All I am saying is, there is this agreement. I've not read this agreement. I don't know what this agreement is per se, in terms of how the court is ruling. Not even in a lot of ways have detailed specifics about what needs to be decided. Maybe the issues, sir, that you're raising need to be decided. What I'm saying is, as to this property, if indeed that's going to be decided in Wayne County as part of this agreement, I'm going to issue the order, I would issue the order of eviction, subject to the date that your next hearing is, and giving enough time so that your interest in regard to that settlement can be protected by Mr. Fair. That's all I am saying. I'm not ruling that there's going to be an eviction. I'm not ruling any of that.
Then why rule at all? Why not
Because
wait
it's
till-
my job.
Okay.
Sit down.
Sorry.
Judge, can we rest at this point, and then I have a rebuttal after you speak to brother counsel? You know,
I worked on this.
He needs to get out.
well, yeah.
I think you better go out. I'm gonna pass it briefly. You
Well-
need to go out and check your
Oh,
client.
no, Judge.
No, go out and check your client.
I will, Judge, but he's fine.
Court recalls the case of the Totoro versus,
Good morning again, Your Honor. Eric Ladat on behalf of the plaintiff.
Good morning, Your Honor, and Your Honor, Darwin Fair on behalf of, and Your Honor, if I may, if I could just make one last statement, give Brother Counsel an opportunity to talk. And I can give just a little bit.
go ahead.
So, all right, Judge. Plaintiff counsel knows the posture. It's based upon what's happened in the past. So they filed a motion to close the case because that is the question, Judge, you always ask, and you wouldn't rule because of the circuit court. So they filed a motion in front of the Wayne County Circuit Court asking that the case be closed. And that was up for hearing a Friday ago. Well, we've been down this road before about a notice of hearing and a precipice. So the precipice wasn't accepted. But at the same time they filed the motion, Judge, they thought or presupposed on that date the judge would rule in their favor. And so at the same time, they filed motions for eviction in this court and also 35th District Court. Well, we both were alerted that the Wayne County Circuit Court was not going to hear the Wayne County Circuit Court case when they had noticed it for hearing. And I was notified by plaintiff counsel that, well, I'll let you know when the precipice is accepted, which means the hearings before this court had to be pushed off until after the Wayne County Circuit Court made a decision. So that is where the breakdown occurred, because then the Wayne County Circuit Court accepted the precipice for the 18th. And so initially the thinking was, well, let's just adjourn this case until after the 18th. I reminded Brother Counsel, we've been down this road a million times. What happens is whatever date that the Wayne County Circuit Court comes up with, oftentimes either doesn't occur, or if it does occur, the proverbial can gets kicked down the road. Then there was a breakdown, because at that point, Brother Counsel says, well, let's just go with the hearing, even though this hearing was initially scheduled because it presupposed the Wayne County Circuit Court would make a decision before we got before this court. And so that's why my initial argument for the court was, I don't know why we're here. So, Judge, I would like to defer any further argument unless the court has questions. So after Brother
I have
Counsel.
no questions. Counsel?
I have no objections, Your Honor, to the court entering the order of eviction, but not allowing its perfection until after July 28th.
Court having heard argument on this case, the plaintiff's motion to lift the stay to the extent that there was one and enter an order of eviction is granted. A writ of or an order of eviction may issue, but here's how I'm going to do it. I'm going to issue it with a firm date of August 1st, 2025 or thereafter. The 56-day rule on the issuance of a order of eviction is waived by the court. That, and so that the record is clear, that should give enough time should the defendants wish to seek other relief before the Wayne County Circuit Court. They may do so. It is a period after the hearing, and actually it would extend the period out originally contemplated by the court. Regarding the 10 days, it extends it out a little bit more than that. So, all right, thank you.
Thanks, Judge. Always a pleasure.
The order,
I need you to prepare.
Yes, Your Honor. Perfect.
Thank you.
Judge, can we put this on the record that I need to see the order before it gets signed because brother counsel has a habit of sending orders that I have.
You know what? I'm not gonna be between the council. Go out there, get a form order. You guys fill it out, approve it before you leave my building.
Sounds like a plan.
Yes, sir.
Also the motion, I didn't know if you were addressing it. No.
Oh. There is a motion, another motion.
Yeah.
Let me get this order here.
Yes.
Yes.
That's the order.
To use that intro quick, Your Honor, but may have something to say or.
No. We're not going down that road, Your Honor, please. If she won't file an appearance and she wants to, it's not appropriate for her to interject herself into this without being on the record, period. I'm not. Once again, she doesn't have a dog in the hunt.
I've signed this. We'll get copies to you.
It's a dog.
Thank you.
All right.
We don't fight dogs anymore.
Oh, right. Gonna have PETA down here in a minute.
I know when the motion was submitted, there was submission statement that she's not representing. That's based into my knowledge on. It's submitted for her, but she's not represented by counsel, so we're prepared to move forward with.
Is she here?
She's on. She was in this.
She's possibly dialing.
Hello,
Hello, what's your name?
Denise Llewellyn.
Okay, Miss Llewellyn, I guess I'm gonna do it this way. Are you intending on being represented by counsel? Pardon?
Yes. Legal aid. Sign was legal aid.
Yeah, okay. Are you guys gonna represent Miss Llewellyn and file an appearance and answer?
File an appearance and do not intend to represent Your Honor. But we are very familiar with the situation, and if the court has questions, I'd be happy to.
Yeah, but Mr. Friedman makes a good point. I don't know who's, from the court's perspective, I don't know who's answering back. I mean, it's sort of, I'm getting these sort of phantom arguments and I can't, it can't operate that way. More importantly, Miss Llewellyn, I mean, in fairness to her, I think she believes she's being represented.
I've
But
been dealing with this since
Pardon?
court started. I said I've been dealing with legal since we've been started almost a year ago. With
Okay, you
Arbor
broke
One,
up there.
know.
Say that again, Miss Llewellyn.
I said I've been talking to legal aid since Arbor One been going to court. So I thought I was represented because I've been talking to them. I've been emailing them. They've been emailing me back. I don't understand what's going on now.
I believe that Ms. Llewellyn was.
May I approach?
Because I've been trying to break my lease.
Okay, hold on, Miss Llewellyn.
Okay. This is a lot. I've been dealing with this shit since the beginning. Jeez. I sure did just cuss in the court. I'm sorry.
Okay, folks, in this matter, record should reflect, we've had a brief bench conference. Miss Llewellyn, I'm going to adjourn your matter to July 8th, 2025 at 2 p.m.
Okay.
Okay? During that
Okay.
week or so, I need you to talk to legal services. And my purpose in adjourning it is so that there's a clarification on whether or not they are representing you or whether or not you are going to proceed on your own.
Okay.
All right? Thank you.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
This shit is retarded.
Person at the jail, what is your name?
James Johnson.
This is the case of the people of the state of Michigan versus James Joseph Johnson, case number 252921FY. We're here for an arraignment. Mr. Johnson, what is a good mailing address for you? You're in Cadillac?
Yes, sir.
And do you have a telephone number?
I don't have it with me, but it's in my phone and I can give that to you guys as soon as I get to my phone.
All right. Did you have the opportunity to meet with somebody from the public defender's office today?
Yes, sir, I did.
I have a complaint that alleges that on or about June 30th, 2025, here in Herring Township of Wexford County, it is alleged in count number 1 that you committed the offense of larceny $1,000 or more, but less than $20,000. It's alleged that you stole an Amigo scooter that belonged to Walmart. That is a 5-year felony and or a fine of $10,000 or 3 times the value of the property taken. Additionally, the prosecution has charged you with as a habitual third offender. That means that you have at least 2 prior either attempted or completed felonies in your past. That makes the 5-year felony a 10-year felony. Do you understand that?
Okay. I'm just kind of like, yeah, blown away.
So I don't want you to say anything about the case, but my question is, do you understand that based on the information that the prosecution has, that is what they've charged you with, and those are the potential penalties?
Okay, yes, I understand that.
All right. On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to. And you have the right to stop answering questions. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford an attorney, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Do you understand that?
Yes.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request the appointment of attorney.
What is your current source of income?
I've only been able to work this last 30 days. I was going to start my job, so at current point is 0.
The court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a prelim. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that this crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. If they are able to do that, you'd be bound over to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That is where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. Do you understand that?
Yes, sir, I do.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I have received the praxis in this matter. It scores him at a risk level 3. Historically, I show in 06 an NSF check less than $100, in 06 an attempted aggravated assault, in 99 a possession of marijuana, 01 petty theft, 05 possession of marijuana, 08 assault, touch to injure, 08 spirituous liquor in a park, 09 disorderly conduct, fighting, 11 criminal trespass 2, 10 criminal trespass 2, in 10 a false information report ID upon arrest, in 12 theft with a value of $500 to $24,999, and 11 criminal mischief 3 with damage of $500 or more, in 11 criminal trespass 1, in 12 criminal trespass 1, 14 criminal mischief damage $250 to $749, in 14 a criminal trespass 2, in 19 a criminal trespass 2, 18 disorderly conduct, 20 disorderly conduct, 20 criminal trespass 2, 21 assault, recklessly injure, 21 assault, recklessly injured, 21 disorderly, 20 resist, interfere, arrest by force, 21 criminal mischief, 21 criminal trespass, 22 assault, 4 cause fear or imminent injury, 23 a DUI with a BAC of a 0.08 or higher, and 23 driving while a license canceled, revoked, or suspended with a previous conviction. Those are all out of state convictions. Our local record shows an 89 a disorderly, and 90 an open intox, 92 an operating while visibly impaired, 92 an open intox, another open intox, and 92, and 93 sell, furnish alcohol to a minor, and 93 an open intox, 94 receive and concealing less than $100, and an 89 in MIP. Any comment regarding bond, Mr. Roberts?
Yes, Your Honor. Mr. Johnson does have strong ties to this community. He's staying locally and additionally has family in the area that he's in communication with. Additionally, while he's not employed, he is working on getting more consistent employment and has been working doing like tree pruning and stuff like that. We don't believe he's a flight risk. Additionally, believe the court could protect the community with non-monetary bond conditions. We would ask for a PR bond or a low cash bond one. Thank you.
When you say he's tree pruning, is that like normal hardwood trees or is that Christmas tree pruning? Do you know?
Christmas trees. Work he was moving to was going to be the Christmas tree pruning. That's right.
Okay, thank you. Prosecutor's office?
Thank you, Your Honor. The defendant was found in the drive-through at Taco Bell on a scooter that he stole from Walmart. He did admit to officers that he planned on driving it home. There was also, officers saw an open box of bagged wine in the scooter, as well as an almost empty bottle of brandy. There was a PBT done, which was a 0.171. Given that, I do think, along with his extremely lengthy criminal history, I do think a monetary bond would be appropriate. I would also ask for random alcohol testing as well as no contact with Walmart. Thank you.
Was it reported that he had taken the scooter from Walmart, or did law enforcement just come upon him in the drive-through?
Your Honor, it just states they received a report of a male in the drive-through on a scooter from Walmart.
Okay. Well, Mr. Johnson, despite your rather lengthy criminal history, I do not find that you are a threat to the community, nor necessarily a flight risk. So I'm going to release you on your personal recognizance. You are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. Because alcohol is alleged to have been a factor here, I'm going to order that you not consume alcohol, and you'll be subject to random testing. Additionally, you are not to use any recreational marijuana and be subject to random testing. You are not to have any contact with Walmart. Do you understand those conditions?
Yes, sir, I do.
Do you think you can live with those conditions?
Could I ask one thing? Could I still smoke herb because it helps me keep from drinking? I've went so long without drinking and just gave in yesterday. If I could just smoke herb, I can do that, no problem.
Do you have a medical marijuana card?
No.
Then for the time being, I don't want you trading one substance for another. And it sounds like, well, So for right now, I will keep the no recreational marijuana in place. But your appointed counsel will know how to bring a motion if we need to do that, all right?
Okay.
Upon your release, you'll need to come over here to the courthouse to get signed up for testing. If you are found to be in violation of your bond conditions, you could be arrested without a warrant, brought back to jail, and have your bond revoked. Do you understand that?
Yes, I do.
All right, thank you. Person at the jail, what is your name?
Brandon Wetterman.
Mr. Wetterman, what is a good mailing address for you?
It's
Is that Manton?
correct.
Did you have the opportunity to meet with somebody from the public defender's office today?
Yes, I did.
I have a complaint that alleges that on or about June 30th, 2025, in the city of Cadillac here in Wexford County, it is alleged that you did commit the offense of malicious destruction of a building, $1,000 or more, but less than $20,000. That is a 5-year felony and or a fine of $10,000 or 3 times the amount of the destruction of the injury, whichever is greater. Do you understand those charges and the potential penalties?
I do.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present at any questioning that you consent to, and you have the right to stop answering questions. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford an attorney, one would be appointed to you at public expense, but you may be required to repay a portion of that expense. Do you understand that?
Yeah.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I haven't thought about that. This is unrealistic. I'm not here willingly. I'm here in not on my own will. I've been forced into doing all this. This has been happening the past several years. I feel like I'm above you people. I see what all is happening, and there's nothing I can do about it. I got people following me around, telling me I got kids. Everybody's telling me buy cocaine. People, let's go Brandon signs, follow me around all over the place. People putting shit in my food everywhere I go. They're switching everybody out here, the judges, the sheriffs, the lawyers. Everybody's been switched out the past few years. I've been just completely tormented, tortured in the past several years.
So, Mr. Wetterman, my question is, do you want an attorney? Do you want to represent yourself, or do you want to hire an attorney?
It does no good. It's not real. There is no law. You can't torture somebody. You can't oppress somebody and hold them here in a jail system. It's not real, dude. I see above all this. It's make believe. It's not real. I don't know what to say. This ain't real, dude. You've taken everything. You raised my property taxes. Okay.
The court on its own will make a referral to the public defender's office for the appointment of an attorney, will enter a not guilty plea, and will set the matter for a preliminary examination. A preliminary examination is a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who committed the offense. If the prosecution is not able to do that, the case would be dismissed. If they are able to do that, you'd be ordered to stand trial in circuit court. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, in 05, I show an attempted assault and battery, 05, a retail fraud third, 05, a retail fraud third, in 20, disturbing the peace, in 23, malicious destruction of a building less than $200, in 23, malicious destruction of a building 200 to 1,000, in 24, malicious destruction of a building 200 to 1,000, in 24, malicious destruction of personal property less than 200, and malicious destruction of a building less than 200. On his local record not shown in his CCH, in 05, there's an unlawful plate, 05, no license, in 10, unlawful plate, in 17, an attempt solid waste disposal, and in 22, a B&E illegal entry. Any comment regarding bond, Mr. Roberts?
I'd say 2 things, Your Honor. First, with regards to bond, Mr. Wetterman is from the area. He has ties to the area with his family. And while he's not working, we don't believe he poses a flight risk. He's indicated to me that In some of the proceedings that the court already noted, he didn't have any failures to appear, so we believe he would show up to court to address those things. We believe the court could address the safety of the community through a low cash bond and other non-monetary bond conditions, excuse me. Second thing I would bring up to the court in conversation without delving into too much information covered by privilege, I do have some concerns with Mr. Wetterman's ability to participate in his own defense. So I just want to raise some competency concerns as soon as possible, Your Honor.
Thank you. Mr. Sharkey?
Thank you, Your Honor. The people are exceptionally concerned with the potential public safety threat that this defendant poses. This stems from an incident where the defendant was throwing rocks at the Wexford County Sheriff's Office. He damaged 8 windows in the process, fully smashing through one of them, totaling in $7,195 in damages. There were multiple civilian witnesses, one who saw the defendant do this from the lobby, one who saw them from his car, and 2 civilian employees who, due to the loud noise of the rocks hitting the windows, believed that the building was under gunfire and went for cover. Sergeant Root of the Wexford County Sheriff's Department heard the sounds, and after being told what was going on by the witness in the lobby, went outside and ordered the defendant to surrender at gunpoint. The defendant decided to throw one more rock at a patrol car in the employee parking, after which he surrendered and was transported to the jail. Given the exceptionally concerning nature of these charges, and that during these events the defendant expressed some sort of vendetta against the Wexford County Sheriff's Department, and the defendant's fairly extensive and mostly recent history of malicious destruction of property and malicious destruction of buildings, the people would request a cash bond of $50,000. Thank you, Your Honor.
The rock that he allegedly threw at the patrol vehicle, did it strike the patrol vehicle?
The report does not say, Your Honor.
Well, the court is aware of Mr. Wetterman in his past. I believe Mr. Roberts is accurate when he discusses the potential competency issue. I know that has been explored in the past in other cases with Mr. Wetterman. Mr. Wetterman does have a history of throwing or at least breaking windows. I know twice at the Shell station in Manton, he broke windows up there so he could get a place to stay. I don't know what was going on this day, but I do find, and if I recall correctly, he probably had not been out of jail very long before this had taken place. So I do find that he is a threat to the community. Well, he might not be a flight risk. He certainly is a threat. Bond will be set at $75,000 cash surety. Mr. Wetterman, if you are able to post bond, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. Additionally, you are not to purchase or possess any firearms or weapons, and that you not act in any threatening, intimidating, or harassing behavior. I should state for the record that Mr. Wetterman's praxis does show him as a risk level 2, which puts him in the low risk category. But given the repeated behavior and what's alleged to happen here, I believe bond is appropriate for now. Anything else, counsel? Thank you.
Good afternoon.
Good afternoon. What is your name?
Bradley Sutton.
Mr. Sutton, you're here on a bench warrant for a failed to appear at financial review hearing. Looks like back on October 31st of last year. There was also a failed to appear back on October 10th. Why was it that you did not appear?
I had just lost my place to live. I was homeless at the time, and I guess I had other things on my mind, and I didn't make it.
I show that you currently owe the court $508. Are you able to pay that today?
Not the full amount, no, but if I get out, I should be able to make a small payment.
How much is a small payment?
I think I have $10.
Do you actually receive mail at this Elmer Street address?
Yes, I do. Yes.
Are you currently employed anywhere?
I'm waiting on disability.
You're waiting on disability?
Yes. Yeah.
All right. Well, Mr. Sutton, I'm going to release you on a PR bond. And I'm going to set this for a financial review hearing. When's our next financial review hearing? We have one next Thursday.
Yes, we do have one on the 10th.
Mr. Sutton, I'm going to set this for a financial review hearing on next Thursday, the 10th, all right?
Okay.
You'll receive notice of that before you leave the jail today. But if for some reason you don't get notice, don't forget about it. Make sure you contact the court and find out when that is, all right?
Yes, sir.
Okay, thank you.
Thank you.
Thank you, jail.
All right, let's start the record. We have two matters scheduled this afternoon for preliminary examination. They're similar. Don Jerome Slater is present. File number is 251042FY. Mr. Slater is represented by Attorney John Bush. In that case, he's charged with delivery or possession with intent to deliver cocaine. Which way it's charged here is a 20-year felony. Second or substantive offense makes it a 40-year felony. And Burgess Montreal Talbert, 251046FY, possession with intent to deliver methamphetamine, 2 counts, as a habitual offender as well. I think all the witnesses are deputies. Jason Van Dyken is the lead officer in each case. And if I understand correctly from Mr. Bush, each client wishes to have their preliminary examination at this time.
That's correct, Jim.
All right, gentlemen, I think you're all aware of this. I told you before, a preliminary examination is a hearing where testimony is taken, and it must be established by the state that if there's probable cause to believe that a crime was committed, probable cause that you did it. You don't get found guilty or not guilty at a preliminary examination. It's just a determination of whether there's enough evidence to transfer or bind over the case to the circuit court. Ms. Davis, do you have any preference to which one we do first?
Well, it doesn't matter anymore which one.
Mr. Bush, you have any preference?
I can do it.
All right, well, let's do Burgess Talbert first. Mr. Talbert, would you come up and have a seat? Mr. Slater, this is a public courtroom. You're welcome to stay here and watch the proceedings. Good afternoon, sir. Are you Burgess Montreal Talbert?
Yes, sir.
Here with the lawyer, Mr. John Bush, and you wish to have a preliminary examination at this time?
Yes, sir.
Laura, I used all my white pads the other day on that zoning case. Could you give me some notepads? Are people ready to proceed?
Yes, Your Honor.
All right, you may call your witness.
Yeah, I want to put on the record that the offer
All right.
is revoked unless he wants to waive today.
All right, well, let's discuss that. What is the offer?
Let me get to it. Josh Robert did the offer. I believe it was 1 count delivery. Restarted, so give me a moment here.
Probably in my notes. Let me get the file up here. No, it was Judge Pattison had this, so there aren't any notes.
Using the new system is not as easy, so I was hoping we can.
I can share what it was, but I'm not trying to jump over it.
No, you're fine. So I want to make sure.
What's your understanding of the plea offer?
My notes, the last offer was possession with the intent to deliver
There would be no drug double and no supplement, and the prosecutor's office would recommend he be screened for adult drug treatment court. All right, the drug double makes a 20-year, a 40-year offense, and the habitual makes it a life offense. If it is reduced to a simple delivery, it would be a 20-year maximum offense. The guidelines would be scored based on that, and they would recommend your placement in the local
Adult drug
adult
treatment
drug
court.
treatment court. Just I got sidetracked here. Do you understand, Mr. Tolbert?
Yes, sir.
If you have the preliminary examination, a day that offer would be withdrawn or revoked. I don't have a dog in this fight, but do you understand that?
Yes, sir.
All right. Spencer, he's joined me for sobriety court staffing.
Yes, sir.
This is the odd number Tuesday, but Judge Pattison is gone this week, so we aren't meeting today.
That's what I thought. Thank you.
We're doing a prelim if you want to get in on that.
No, thank you.
All right. Have a good week.
Thank you. You too. Happy 4th.
You too. All right. Okay, then I guess we're ready to go. Defendant declines plea offer.
Now the people will call Deputy Jason Van Dyken.
Afternoon, sir. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
Thank you. Please take a seat. State your first and last name and spell them for us.
Van Dyken, VANDYKEN.
Deputy Van Dyken, are you on the road patrol for the St. Joseph County Sheriff's Office?
Yes, ma'am.
And were you on duty on June 8th, 2025 of this year?
Yes, ma'am.
And around 12:40 p.m., did you have contact with a Burgess Tolbert?
Yes, ma'am.
Tell me how that came about.
While stopped at the light at Michigan Avenue and southbound 131, I observed a vehicle in my driver's side rearview mirror or side view mirror. After looking out the window as the vehicle approached a stoplight next to my vehicle, I observed the driver making a motion like this, indicating to me that he did not have a seatbelt on, placed a seatbelt on.
And so you were next to this vehicle?
Yes, ma'am.
Is this in Three Rivers?
Yes, ma'am.
All right, this is in St. Joseph County?
Yes, ma'am.
And what did you do after you saw the individual make that motion?
The light turned green. I positioned my patrol vehicle behind the vehicle that I observed the driver without a seatbelt on and conducted a traffic stop on the vehicle for such.
And as part of that traffic stop, did you come into contact with Mr. Tolbert?
Yes, ma'am. He was sitting in the front seat, passenger seat.
And the person that you identify as Burgess Tolbert, is he here in the courtroom today?
Yes, ma'am.
And can you point him out for the record?
He's the black male sitting to the left of Mr. Bush's right, my left.
Your Honor, may the record reflect he's identified the defendant.
It may.
And after making contact with the driver and Mr. Tolbert, what happened?
I gathered both of their driver's licenses, ran them through lien. Mr. Tolbert was found to have a warrant. He was taken into custody for his warrant.
When you took him into custody, did you transport him to the St. Joseph County Sheriff's Office?
Yes, ma'am.
And what happened when you got there?
After searching him on scene and not finding anything of evidentiary value, he was transported to the sheriff's office jail by myself. After arriving at the jail, he was removed from handcuffs by jail deputies and placed into the jail's receiving body scanner, which is located at the building.
And what is the body scanner used for at the jail?
It is used for the detection of anyone that may be smuggling illicit substances or items inside the jail that the jail determines or defines as contraband.
And did you observe anything unusual in the defendant's body scan?
Yes, ma'am.
What did you see?
After being alerted by the jail deputy that was utilizing the body scanner, he informed me that he would like for me to take a look at the screen. The screen depicts an X-ray similar to what you would see at a doctor's office of a human body that's X-rayed, but it's in the X-ray is over the entirety of a human body. Somewhere in or about the genital region of Mr. Tolbert, there appeared to be a bulging object that was clearly not part of his person, concealed again in or about his genital area.
And you've been a police officer for how long?
I graduated Police Academy in 2018.
And have you regularly done illegal narcotics investigations?
Yes, ma'am.
All right. Was there anything about this that struck you as unusual?
Not as far as narcotics investigations, no, because based off of my training and experience, I have commonly located contraband being concealed on or about the genital area of individuals that I have arrested.
Was he clothed when this scan was happening?
Yes, ma'am.
So after you identified what you believed to potentially be contraband, what happened?
I walked over to the body scanner while Mr. Tolbert was still sitting inside of it. And I asked or gave him an order to hand me the bag. Mr. Tolbert, acted as if he didn't understand what I was saying to him. And I reiterated my comment, give me the bag. I know that you have something on you or something to that effect. To which then he reached inside of his pants and produced a plastic baggie that later was identified to be containing methamphetamine.
And how do you know that it was methamphetamine?
It was tested for methamphetamine, if I do recall correctly. And during an interview with Mr. Tolbert, he stated to me that it was methamphetamine.
Do you recall how much there was and how it was packaged?
I believe it was approximately 1.61 ounces of methamphetamine, packaged in 3 separate baggies that had product being methamphetamine in each one of the 3 baggies. Additionally, there were empty baggies of the same style, being a plastic baggie alongside of it. So it was one large bag with 3 individually packaged baggies of narcotics with empty plastic baggies alongside of it in the original bag.
And those empty baggies, were those like new or used?
They appeared to not have any sort of residual substance within them.
And based on your training and experience, what does this indicate as far as
It
whether
indicates that
user?
the narcotics that were already packaged, to me, the empty baggies are generally to be used to package smaller amounts of narcotics to be sold at a later time.
And in your training experience, what is a user amount typically of methamphetamine?
Generally, users in my training.
Yeah, I guess he should have been qualified as an expert, but he's giving expert testimony at this point. So I do think we need to call a halt to this and find out what his experience is.
All right, there's an objection, Ms. Davis.
Your Honor, he is a police officer, has been through the academy since 2018.
Why don't you just ask him a couple questions? I think he's probably got the expertise.
Could you describe to the court your training and experience regarding narcotics?
My training and experience regarding the narcotics would be while employed here at the sheriff's office, starting last year in July of 2024, I have over 20 narcotic seizures within a year. I believe that the experience of being able to detect and locate narcotics being concealed on individuals or within vehicles during my duty would give me reason to believe that I generally don't find more than 1 gram to 2 grams on any given person at any point in time who's not selling or does not have products or items that are commonly used for the sales of narcotics.
Do you do any continuing education training throughout the year?
When it's available.
And in those trainings, have you done any specific to narcotics?
Yes, ma'am.
And can you explain to the court kind of the background of those?
They're trainings that are given online that are mainly directed at areas of concealment on persons or vehicles that I have attended online in reference to the illegal transport or carrying of narcotics.
Your Honor, I believe that he has sufficient knowledge for giving expert testimony as a police officer with training experience in illegal narcotics.
I think so too. I think that Mr. Bush's objection was well timed, but I think you've established a record that this officer is qualified to testify about his knowledge of street user quantities of methamphetamine as a police officer investigator. So you may answer those questions.
Deputy Van Dyken, going back to this amount of methamphetamine and the manner in which it was packaged and the existence of other packaging materials, what would that lead you to believe as being a user or somebody who is potentially dealing?
Based off of my training and experience, the quantity of narcotics that were located on Mr. Tolbert is not generally a user amount. Based off my training and experience in contact with individuals who I have recovered narcotics from being concealed on their person, who have openly admitted to me to being users. In those instances, those have never been in quantities above an ounce.
All right, so do you know how many grams there are in an ounce?
I would have to refer to my notes, but I have it written down in an area to where I have that documented as a cheat sheet for grams to ounces or grams to a quarter, half, or a third of an ounce. Something that I commonly refer to.
Is it somewhere like 27.7 grams or grams per ounce?
I would say that's close.
How much does a person typically consume if they're a regular user of methamphetamine?
It would depend on that person's daily or weekly use.
Minimum amount versus?
I would say there's no minimum amount. During my time as an officer, I would say that there are people who have admitted, not Mr. Tolbert, but people that I have had interactions with to using narcotics admit to me to use daily, bi-weekly, bi-monthly. It depends on how that individual is using narcotics.
And I'm sorry, how much like at a time, like a gram at a time, or?
I would say less than a gram at a time, but perhaps it wouldn't be unusual for a user to use a gram throughout a 24-hour period.
Did Mr. Tolbert make any statements or admissions about why he was carrying this?
He admitted to me that he knew that it was methamphetamine and stated that he had been around it and claimed to me to be a user.
I don't believe I have any further questions at this time.
Mr. Bush?
Did the driver of the vehicle, was it determined to make any arrest on him for anything?
Can you ask that again, sir?
The driver of the vehicle, was it determined that he would be arrested for any violations as part of this investigation?
No, sir.
And did you have a partner that was with you during this stop?
No, sir. At one point, a trooper with the Michigan State Police showed up, but did not exit his vehicle or assist me at all.
So when you went to the vehicle, which side did you approach first?
Passenger's front door.
And why was it the passenger as opposed to the driver?
It's a common tactic that I use. If I'm along the highway, I normally step away from the flowing traffic that goes down a road. So it's not uncommon for me to still employ that tactic even if it's in a parking lot.
So in your mind, that's a safety feature that keeps you off the highway then?
Generally, I'm farther away from the traffic that goes down the road, yes.
Did you search the general proximity around inside the vehicle of the defendant?
I asked for consent to search the vehicle and it was denied by the driver, which is his right to do so.
So was there a search completed incident to the arrest?
Of his person, yes. Of the vehicle, no.
Was the vehicle ever searched?
No.
regarding his person, did you find any amounts of cash?
I don't recall.
If you would have found like $3,000, would you written that down?
I would imagine I wouldn't mistake or misplace or forget about $3,000.
But reason being, people are distributing drugs and they have cash, so did you find any cash?
No, not on this person.
Did you find on his person any scales?
No, sir.
Did you find any ledgers or notebooks keeping track of transactions?
No, sir.
And sometimes with narcotics transactions, there's multiple cell phones involved. How many cell phones or a cell phone did you locate on?
So it should be noted that upon demanding him out of the vehicle to place him in handcuffs for his warrant, I observed him actively take his phone and throw it back into the car to the driver, which the driver then recovered and remained in the car. I know that drug sales commonly are organized or orchestrated by the use of digital communications, cell phones, Facebook, Snapchat, or any sort of digital media or communication application that can be utilized on a cell phone.
Was there ever any follow-up to get that cell phone to see what?
It would have been one of the intended points and purposes of me asking for consent to search the vehicle, but ultimately the driver of the vehicle exercised his right to deny me consent to search the car.
Did you ask Mr. Tolbert if he'd used any drugs or narcotics recently?
During the traffic stop or during the traffic stop?
Well, so within 24 hours of when you came in contact with him, did you ask if he'd used any drugs or narcotics?
I don't recall.
And if somebody was to buy drugs illegally under the table on the streets, would they not be packaged in the form that you saw them?
Would they not be
I
packaged?
mean, would they be packaged in that form?
Well, one of the baggies of methamphetamine packaged was in a quantity that is less than an ounce, more than a gram. That is, in my training and experience, something that a user would purchase, yes.
Thank you. I have no further questions.
Thank you, Ms. Davis. Anything further with this witness?
No, Your Honor.
Thank you, Deputy Van Dyken. You can step down.
Thank you, Your Honor.
Any further evidence, Ms. Davis?
No, Your Honor.
Mr. Bush?
Defense progressed, Chairman.
All right. Motions?
By the evidence presented by Deputy Van Dyken, I believe that the people have shown that there's probable cause to bind over on both the possession with intent to deliver controlled substance methamphetamine, as well as the possession of the methamphetamine itself. Mr. Tolbert admitted to the methamphetamine being what it was tested as such. As far as the packaging of it and the amount exceeding the regular user amounts, as well as his behavior of throwing his phone off of his person into the vehicle, which is in modern times where people are keeping track of their sales and making contact with people, as opposed to in the olden days having notebooks and ledgers. The defendant was identified by Deputy Van Dyken. He was a passenger in a traffic stop and he had a warrant. So he was searched to arrest. He then chose to not reveal that he had these items on him, and then they were found by the body scanner and ultimately seized at the St. Joseph County Sheriff's Office. So with that, I would ask that he be bound over as charged.
Mr. Bush, your response?
Thank you. May I sit down?
Certainly.
I concede to the court that Ms. Davis has met her burden on count 2 on the possession of methamphetamine. I suggest to the court the issue today is what was in my client's mind. Did he have the intent to deliver those narcotics. A lot of typical things we expect with a drug dealer weren't there. Cash, scales, ledgers, those are the things that we seem to deal with traditionally, shows somebody to be involved in trafficking narcotics. My client admitted that they're his, he said it was for his personal use, and I would ask the court to not bind over on count one.
All right, Mr. Talbert, you're charged with, you're good, with possession with intent to deliver, which is the same as delivery, and then possession. Your lawyer concedes that the evidence shows you did possess it. The question here is whether you possessed it with intent to deliver, which enhances the punishment by double. As I told you before we started, this is a probable cause hearing. Now, there's certainly probable cause to believe that you did it. You were the only one there. There's no issue of identity here. Question is, did you have a deliverable quantity? 1.6 ounces. I wasn't clear whether that was just the product or product and packaging. But rule of thumb is about 28 ounces per 28 grams per ounce, actually a little more than that. But an ounce user quantities, there's more than enough for sale, packaged separately in 3 separate smaller bags. Also unused bags or unresidue bags that could be used to repackage it. So there is probable cause. I'm not making a finding there's proof beyond a reasonable doubt. There's probable cause to bind this matter over to circuit court on both the possession and possession with intent to deliver. The drug double and the habitual simply go along with it. We don't need to make a finding on that here. You posted a substantial bond of $15,000 cash or surety. You've made all of your court proceedings. I'm about to lose jurisdiction over your case. It'll be transferred to the circuit court. We show an Albion address, but I know you were at some time a Three Rivers person. Where are you living right now, Mr. Talbert? You're in Albion. All right. All right, as I said, you've made every court proceeding. You've been in contact with your lawyer. The plea offer in this case is revoked. Drug treatment court seemed like a good option, but I suppose a new plea agreement could be fashioned if the matter can't be resolved. If it can be resolved, you're entitled to have a trial. That'll be some time from now. The next step in the proceeding, the matter will be set for a status conference, probably not until several weeks from now, maybe September or even later. So stay in contact with your lawyer. I don't think he's on pretrial services.
I don't believe so, Your Honor. I would ask that the court, because there's been some question about the form that we've been using with bond, that the bond conditions reflect that he is not to violate any other law in the state of Michigan and not leave the state of Michigan without court approval. There's already the abstinence, not consuming alcohol or using any controlled substances except as directed by the doctor, and submitting to tests upon demand of any police officer. So I would ask that be not use or possess any of those.
Fair enough. I thought the bond form had those standard conditions, no other criminal activity and may not leave the state without permission. But nonetheless, those are the conditions. There's no allegation you've done those things. But the matter will be bound over to circuit court set for a status conference.
Thank you, Your Honor.
Mr. Talbert, do you have any questions?
Yes, if you have any questions.
No, sir. No, you're good to go. Deborah, I did a bind over. I didn't get one in Slater. I couldn't print one, but here's this one. You can scan it in and then make sure we get it back. Both your clerks and my clerks are mad when we don't give them up to bind over. There's a fight over who gets it first. And as I said, I don't have one in Slater.
respond here?
Yes.
Your Honor, we were able to locate an expert that's specifically an expert on email forensics in Microsoft Outlook. And we did not obtain that person until last week. And I did not have a report in my hands until Thursday evening, which I didn't read until the morning before I sent it on to the prosecutor. So this is a new witness. And I told the prosecutor that I don't know if we're going to call him because it depends on whether Detective Parvis is familiar and is able to answer my questions on the various indicators of this email that I want to get into. So, but if the court is not inclined, I won't. But I just want to be able to have the witness here in court to observe, since he might be required at the next level if it goes there.
But your questioning Detective Parvis is going to relate to that new report.
It is, but I'm not going to ask him about the report. I'm just going to ask him about the concepts, Your Honor, and ask him what he saw in the artifacts that he looked at in the server log and other places. So I'm just asking the information. I'm not going to show him the report or ask him about the report.
Well, I guess I'm at a bit of a loss as to how you're going to do that without referencing the report.
It's just concepts and things that Detective Parvis.
Right. Okay. I hear you, but are these new concepts?
Well, I haven't had.
And are they new concepts that one would have to prepare to address them in a form? I mean, part of my concern is, counsel, is that if you're going to do that, then Detective Parvis's testimony could be misconstrued in terms of his response.
I'm not sure what you mean.
Well, let's say there's something in the report that says something. I can imagine a circumstance where you ask the question, Detective Parvis answers the question based upon a certain understanding. That answer is then locked in. But then later on, there is this other really understanding that had that context been put on, there may have been a different response.
I don't intend to ask anything out of context. I intend to explain my questions and ask him about context,
but
what he saw and what he didn't see. That's all.
Right, but it's going to be, I get what you're saying, but the context of some of your questioning is going to be based upon the experts your experts analysis, right?
He told me about concepts and he told me what he saw and didn't see. I want to ask him what he saw, and I think I can question him about what.
Well, no. Your expert, well, just in terms of just what you just said, your expert told you about what he didn't see, what he did see, right?
I want to ask him if he saw those things.
Well, I get you, counsel, but what I'm saying is your expert is giving you the framework for your questioning, right?
He didn't write my questions. He told me about concepts and what he saw. And
say that he wrote your questions.
But I don't even know.
That's not what I'm asking. What I'm asking. Let's try it this way. To ask the questions that you're asking because of your expert's analysis. Nothing wrong with that, but that's how you know what questions and what areas to probe into. That's fair, right? I mean, because that happens with any, right? Right. So if there's a report, a new report that just gets to the prosecutor. Because, well, let me back up. There was obviously a previous report, right?
Yes, Your Honor.
That then generated another report from Detective Parks, right?
That's correct, Your Honor.
Yeah, because that was the last part of the question.
Yes, yes.
Now there's going to be your questions to Detective Parvis based upon a new report. And let me just ask this. I haven't seen the report or anything. Does that new report come to the same conclusions as your previous report?
Yes, but for different reasons.
Exactly. That's exactly what I was going to say. It comes to the same conclusion, but for different reasons. I think it would be highly unfair as we sit here today to, how long was this report?
I have a
I
copy.
think it's 15 pages, Your Honor.
Okay.
So the digital forensic report itself is 13 pages. Included with it was also the person's CV, as well as just a copy of an email correspondence.
And you're saying you just got this report
Thursday,
Thursday.
but evening, I believe, I'll double check. But again, we don't have to call the expert.
Right. But that's not the only issue, counsel. Part of the issue is you calling the expert. Part of the issue is, and I'm not saying anybody would be doing anything wrong, the way in which you frame the question, the context in which you're asking the question, which is going to be framed by, I would presume, that report. And then the response, the response to the question may have significant bearing. Let me strike that. The context of your question may mean something very different to Detective Parvitz, which may then guide his answer. And so what I don't want is I don't want responses that are going to then be misconstrued in some way, especially when we're talking about expert testimony.
Can I respond? So we have an expert on the stand, an expert that presumably knows about the concepts I'm going to ask him about. I'm simply asking him about concepts such as, if you looked at the server log, what was the source for the transmittal? Was it a certain type of source, or was it some other source? And I'm simply asking him what he observed. I don't know how this is unfair to an expert. And certainly if something is misconstrued or it needs to be clarified, the prosecutor can do that also.
Well, that's part of the problem. Certainly they could do that, but they've had the report for what, 3 days?
Got it almost at lunchtime on Friday. It's Tuesday, just about 2 o'clock. So no, I have not had time to read through it, Your Honor. Unfortunately, this is not my only matter that I have to work on.
And also, counsel, that you say that, let me ask this, because it may have been your intention, it may not have been. As I understand it, you had indicated to the people you were going to call this expert today.
He said he may call, yes.
Okay, May. Okay.
But I don't have to, and I won't. I just don't know how I could have my cross-examination curtailed by the fact that I got some information.
By what?
By the fact that I got information from someone who knows the topic. So for instance, if this were like a skid mark case, the issue is how long was the skid mark? And if an expert told me, hey, ask them this question, and I came in and asked the question, that's not unfair, and that's not, the defendant has a right to cross-examine, as you know. And so I think that right.
It would take counsel, that's a very simplistic analogy to this, because I don't think this isn't just a skid mark. If it were just a skid mark, then okay, you could do that. You're actually talking about rather complex things that then have to be arranged in a certain way to come to some type of conclusion. And that's part of the problem. Ms. Lonnie.
I just want to say that the people are not attempting to curtail the cross-examination of Detective Parvis in general. It's just with the late disclosure of new information that myself nor the detective have had time to review. It does not seem that the way forward today is to allow that. Now, if that is the hope, is to cross-examine with some of this new information, I'm sure we can find another date that allows everybody to be ready for it. But trial by surprise, the people do not believe is fair to either side. And having a hearing that conducts itself with sort of last second information that doesn't leave either side adequate, leaves one side unadequately or inadequately prepared to move forward, does not seem to serve the interests of justice.
Your Honor, I didn't even have to give her a copy of this report. I could have just come in and asked my question. So I don't understand why me being upfront and trying to say, because I'm trying to convince the prosecutor to drop this case, because I don't think it's my client.
Counsel, I understand. I'm
trying to share.
I'm not getting into anybody's strategy about why they're doing what they're doing. What I am getting into right now, though, is whether you should have. You did, right? And so then the question becomes, how do I balance this to make sure that not only you get a chance to ask questions fairly and get a proper response, but at the same time, also making sure that it's not mistaken. I mean, I also, counsel, I'll just say, I think it also behooves you not to have the responses misunderstood, right? Because I don't care what anybody tries to say about the simplicity of your questions. I think you're going to be asking questions based on that report. Again, nothing wrong with that. But I also think, much as the prosecutor might be concerned that a response that comes from Detective Parvis is subject to being misconstrued because he hasn't read the report, you're also may have a question that you want a response to that Detective Parvis isn't going to be able to say, well, I didn't read that report that you're talking about. So
my response to that, Judge, is that if I ask a question and he isn't sure of the context, or he can easily qualify his answer and say, yes, well, it depends on all these different things. And if he hasn't seen any report, then he could do that.
Certainly you could. But the problem is the universe that the question is being answered in now has just expanded. And
can I respond to that last part?
Sure.
I don't think it's expanded, Judge, because it's all going to be based on a server log that they had since 2023. You know, they had the information. They should have looked at it. They should have understood it, and they did. They misconstrued it. And I want to ask questions about that without giving necessarily Detective Parvis a chance to try to figure out some way around it. Honestly, and in fact, I didn't even hold back. I gave the report to them on Friday as soon as I was able to read it and give it to them. I did not hold back on the report. And I have, by the way, I have Mr. Greenberg. He's in court today, the fellow who wrote the report. If you have any, if you want to ask him about the timing, but I assure you that I did not hold back on this report.
I'm not saying that you are. That's not my issue.
We just really don't want to put this over. This is what Ms. Carey's did there.
What?
We don't want to put this over, that's all I'm saying.
All right, I get that. But I also set aside a half a day because you told me that you wanted to do whatever. I get this when I walk in. And regardless of whether one wants to or not, I'm going to do what's,
Of course.
make sure that it's a fair proceeding. That's what I'm going to do. So, Ms. Lundy, have you had an opportunity, and probably not, I just want to make sure to analyze even the CV?
Barely, Your Honor. I've glanced through it. I've looked at some of the work history and a little bit of the education. Detective Parvis and I had one phone call Friday in the lunch hour I let him know that it was coming. There was a new thing. He informed me he was in a week-long training last week and did not have a chance to look at it. And then I think we spoke again today before court. But other than that, I've just literally skimmed. I haven't had a good opportunity to analyze any of it.
And just looking at it, if one had the time, how much time, if I decided to go that way, would one need to be able to adequately have it, understand it, and respond?
May I have a moment? I am completely unavailable next week as I'm currently scheduled to do a week-long murder trial in front of Judge Conlon with Emmons. So I'm not available next week. I could potentially look at the week of 14th to the 21st, but the challenge too is Detective Parvis currently, as he shared with me, and I asked if it was okay if I shared permission. He is currently 6 months behind. There's no new work with CSAM cases, CSC cases, homicide cases, robberies, armed robberies, all sorts of different things requiring forensic analysis. So I think we're looking at August for us both to be ready.
So what, rather than indicating the exact day, between the time of where you told me when you received it, when did you request this expert analyze anything?
I didn't. It was a fellow who came forward who lives in the township, right? Lives in Scioto Township. The expert is from Scioto Township. He came forward and provided the reports to my client, who provided them to me. So that's how it happened. I didn't.
Gotcha.
So it's not
okay. It's not like you went out and hired an expert.
He's not a hired expert right at this point. He's a concerned citizen that knew that he is an expert, but he wanted to provide his.
Well, so that I'm clear. The citizen of Scioto reached out to your client.
I don't know how that worked, but I can ask him. He's here if you want to.
Well, I'm just trying to figure out how it came about and when it came about.
Can I have a moment?
Sure. Counsel, when you're talking, you may want to hit so that it has to flash. It has to be green, so you have to hold it. There you go.
Thank you. I think I understand.
Right.
So my client had FOIA some information. She did a FOIA to get information, and she found an email that contained additional server information that.
Hold on. Your client did a FOIA to whom?
To Washington County Sheriff. No, sorry.
To Scioto, may I speak?
Yeah, that's fine. To Scioto.
Scioto Township. Going back a couple of years, and I found an email from our IT, Chris Bailey, to N1 Discovery stating, here is all the information. N1 Discovery is what Scioto Township had hired an expert forensic, and it was the same information that they provided to the sheriff department. And this was back in early 2024. And I didn't know about this. Apparently the sheriff had it based on Chris Bailey's email to this person with N1 Discovery.
Okay, I don't want evidence of anything. I'm just trying to figure out, you get that information. What did you then do with that information?
I found the information and I had questions, so I called Jonathan because he is an expert in Outlook in Microsoft 365. I didn't know what I was looking.
Jonathan is the person that prepared this
Greenberg.
report.
Mr. Greenberg.
He's the one that did the newest report, Judge.
The newest, right? That's what I'm saying.
Gave me the information to ask the questions today, like I said.
Okay, all right. Court is standing in brief recess. I'll come back and give my decision as to whether or not we'll proceed today.
Thank you.
Thank you, Judge.
All right.
Okay, the issue has come up regarding this new report. As I would if the people came up with additional evidence and defense were in a position to potentially not be prepared to address it, I would adjourn it out. And I think only in fairness can I do that here. To adjourn these proceedings, allow them to analyze the information that's been presented to them. And then formulate what may be redirect, quite frankly, of Detective Parvis if necessary. So I analyzed it in my head in a lot of different ways. I'll say this, it's not necessarily any of my business. I'm also concerned because typically with experts and other types of witnesses, those derive from sort of counsel doing that. And it's clear to me that this did not derive from counsel, which I think also causes at least some pause in terms of that, because I don't frankly know, and I'm not asking whether or not counsel, because he's the one that has to make the representations to the court and to other things, has had his adequate opportunity to vet what's there. So that is also a concern of mine.
Sorry, I didn't hear the last part, Your Honor. I apologize. I didn't hear that last part. You're concerned that I didn't do what?
To vet what's there. The timing of all of it is very odd to me.
Okay, yeah.
Okay, and so that's also a concern for the court in fairness to the defense in terms of the questioning. So, I mean, there's a lot that's kind of going on here. And so from my standpoint, I'm going to take the approach, while it certainly may delay the proceedings, I'm going to do my best to try to make sure that it's fair. So
Can I be heard just to make my objection for the record? For the record, this adjournment is over my client's objection. And I want to say
what's the
that,
basis of the objection?
sorry?
What's the basis?
Her objection is her Sixth Amendment right to cross-examine and confront the witness against her.
That is not being kept quiet.
Okay, sorry, I'll let you finish. Let me know when I can talk, because I just want to make a record. I will.
Yeah, but you're making a record of things that don't exist.
Okay, but
are you indicating that the court is taking away her Sixth Amendment right to cross-examine this witness?
I'm indicating that by essentially sua sponte moving this proceeding, the court is intervening and moving this hearing in a case where I was not going to even introduce the expert's testimony or his report. So the court is moving this to give essentially an advantage to the other side. So that's, I'm making my record.
Recess.
District Court for County of Washington, State of Michigan is now back in session. The Judge Simpson will drive.
Maybe some. Back on the record in the case of the People's State of Michigan versus Julian Carey. Counsel, you wanted to place stuff on the record. Go ahead.
Yes, sir, I'm sorry. I just wanted to say for the record that this particular case, we think that the adjournment, I think that the adjournment infringes upon my client's rights under the 6th and 14th Amendment. The 6th Amendment being her right to confront and cross-examine accusers against her without any intervention by the court. And the other one would be that the 14th Amendment right of due process for the court not to be fair and impartial. Those two, I just want to put those on the record, Your Honor, and I'm not trying to be adversarial. Thank you.
I don't need a response from people in terms of that. I noticed that you're noticing that for the record. So first of all, before I left the bench, you incorrectly asserted that the court is adjourning these proceedings sua sponte. This adjournment is after due consideration by the court based upon the prosecutor's request to do that. That is not sua sponte, and I am sure that you would understand that being a lawyer, that it was not the court's, it's the court's decision, but it was not the court's motion to do it. So that's the first error that you made. There is no violation of defendant's 6th Amendment rights in this case because the court is not interfering in the right to cross-examine. The court is going to permit effective cross-examination to the extent you can be effective of the witness at a later date. There is no interference. This delay in these proceedings has no effect on that whatsoever. I don't even know how you bottle that up to try to say in some way this court is interfering with her 6th Amendment right to confrontation and cross-examination of the witnesses. Further, in regard to, and I assume as an attorney, you know what due process means, and that means that the court has to be fair to all parties, not just to you, not just to give some benefit to defense. The court considered everything that was raised my own questions about the new report, whether or not that would be prejudicial to the people, whether or not it'd be prejudicial to the defense, weighed that, went back, took time, looked at it, would prefer to go today. Set aside the time at your request, counsel, from the last hearing, that I have a blanket time so that it wasn't with other cases to hear it. I've set aside the time to do it. That's part of due process. Part of due process also is making sure that each side has a fair and adequate opportunity to do what they need to do in this case. It has. Now, those are the legal issues. What incensed this court, quite frankly, because it's something that I take very seriously, is the notion that this court has done anything, ever. And in my 25, almost 26 years, I've never been accused of that. Nobody has said that I have done anything to give one side an advantage over the other. It is not me. And I think, counsel, as you've proceeded through this case, you have seen that. I have never done anything that has said that people are going to have this advantage or to the people that you're going to have this advantage. I call it straight down the line. You get to present your case. I make my ruling. That's how I work. That's how I've always worked. So I will tell you that this court takes great offense when there is any indication that that's what this court is doing, that this court has any untoward motivation in doing what it's doing. That's my record.
You want to respond to that?
At your own peril, counsel.
And to say, I appreciate the court finding that no other cases. I think I really appreciated that. That's why I wanted to get this on today. I mean, I think I think that if there were a legal reason for the court to put it over, then I would understand it. I just don't know what the legal reason is since
The legal reason is exactly what you brought up, due process and fairness to the parties. Prosecutor raised an issue. I've gone through that, counsel.
I'm
Is
done.
there anything else you want to say besides trying to waste my time?
I'm not trying to waste your time. I have nothing else to say. Thank you, Your Honor.
Preliminary examination in this matter will be adjourned. August 12, 2025. 2 p.m. That's before me. We will go that day, folks. Even if we have to be here all evening, we will go that day.